All right, good afternoon, everyone. We're 12 o'clock on the dot. I know we've got a few more members logging in, but we'll get started. So thank you to Ruben and Shannon from LTSA for sponsorship and being here today, I think, to answer a lot of questions that have come up in regards to Lotr. So we've received some feedback and addressed some questions. So I hope that a lot of that will be addressed today. But as always, feel free to enter in the Q&A box at any time and Shannon will answer those for you. Also, the presentation you're seeing today and a recording of this presentation will be available later this afternoon on the members website. So just use your login and let us know if you have questions about that. So on to our speakers. Ruben Danicotti, the Director and Administrator of the Landowner Transparency Registry in the province for the Land Title and Survey Authority of BC. Prior to LTSA, Ruben was with the City of Edmonton's Assessment and Taxation Branch as Director of Integrated Business and Customer Solutions, where he was accountable for business planning, technology support, and service delivery for property assessments and tax collection. Before the City of Edmonton, Ruben worked with BC Assessment for 16 years, where he held statutory and leadership roles as the Regional Assessor of Vancouver Island. Ruben's career also includes 7 years of real estate services and asset valuations and investments advisory services in the Asia Pacific region. So thank you, Ruben, for being here. And Shannon Brown-John is the Deputy Administrator of the Landowner Transparency Registry. Prior to joining the LTSA in this role, Shannon held real estate appraisal roles at BC Assessment, where she was responsible for residential, commercial, and industrial real estate. She has held expert witness roles in property assessment tribunals with experience in interpreting legislation and policies and translating those into business outcomes. Shannon holds a Bachelor of Arts in Economics from the University of Victoria and a diploma in urban land economics from the University of British Columbia. Shannon is also a professional accredited member of the Real Estate Institute of BC. So thank you both to being here, and I will pass the floor over to you.
Good afternoon, everyone. Thank you, Tristan. Thank you, Chad, for having us here. Thank you certainly to BC Notaries Association for inviting us to present today. We're really pleased and that we have the opportunity to do so. And also to all of the notaries throughout British Columbia, thank you very much for participating and allowing us to share some information with you today. It's really hard to imagine that we're close to about 2 months since the launch of the Landowner Transparency Registry on November 30th. And as of today, we have over 30,000 filings of LOTA that includes both transparency declarations and transparency reports. And for today's event, I'm really appreciative of the association for helping us with identifying some of the key subject matters that notaries throughout BC would like us to cover. And we're going to do our very best to address most, if not all of that. So we've got a pretty heavy content today. We're going to get going today. And as Trista mentioned, we'll have an opportunity for questions and answers at the end of the session. So let's cover a little bit of what we're going to cover today. So our content for our presentation, we've been getting a lot of questions and asks around a clarification on key terms. So we're going to cover at least 4 key terms in LOTA. Certainly doesn't cover all of it, but certainly the most common ones, and hopefully we can clarify some of that. We've got a little bit of a cheat sheet that we've created in terms of just knowing when LOTA disclosures might be required. So, and it's an opportunity also just to try and get us all anchored on, when do you need to file LOTA? We've had many questions, and certainly we receive it on a daily basis on how do you apply the Act to the certain scenarios that typically notaries tend to deal with on a regular basis. So we've endeavored to try and provide some guidance here today. And then it's an opportunity for us, obviously, to the LTSA to try and give you a bit of some key things to look out for when you're filing and working with our system, the Lotr system itself. So that's an opportunity for us to actually just point out some things as to to-dos and don't-dos, that sort of thing. And finally, just a quick review of our website and just trying to point you to some of the resources available to help you in your day-to-day work. So let's get going on key terms. So as I mentioned, I'm going to cover four key terms. The first, which we get a lot, is certifications. What are certifications and who is certifying? So there's really two types of certifications. The first is a certification of a transparency declaration or a transparency report by the transferee. So certifications are explicitly covered in Section 25 of Ltsa. So the first part, there's two types of certifications under a transferee. So the first is under Section 25(1). So if the transferee or reporting body is a corporation or a limited liability company, so TDs, I'm going to use the acronym Transparency Declarations and TRs, Transparency Reports. TDs and TRs must be certified by an individual who has knowledge of the matters being certified, and that the individual has the actual authority to certify on behalf of the transferee or the reporting body. So in the case of a corporation, for example, typically from our experience, what we've seen is the director of a corporation that might be the person who's certifying the actual transparency declaration and the transparency report. Now, this is different from the next provision under section 25(2), where if the transferee or the reporting body is actually an individual, so in that case, it could be an individual who is actually going on title and owns that interest in land directly, or if the individual is a trustee of a relevant trust, then the TDs and TRs must be certified to be correct and complete by the transferee or an agent appointed by the transferee or the reporting body who has the knowledge of the matters being certified. Now, some of the questions we have received periodically is, can the legal professional, whether a notary or a lawyer, for example, act as the agent for the transferee? So that is something that we cannot provide direction on. That is something that the legal professional has to make their own decision as to whether they are in a position to be acting on behalf of their client as the person completing the transaction, as well as signing on behalf of their client. So that is something that you as a notary will have to make that decision. The next definition, so the certification by a designate. The designate is effectively you as a legal professional. So section 26 goes to describe the designate as a person in a class designated by the administrator under section 26 of Ltsa, who may certify TDs and TRs using their electronic juriscert certificates. So as I say, it's the legal professional who has the juriscert, who is ultimately after the transferee or the reporting body has wet ink signed, and there is the true copy of the execution copy. You're then applying a juriscert to the TD or TR. Next two key terms are interest holder. So we frequently get questions and some confusion as to whether the interest holder could be a company. So the interest holder in Ltsa is always an individual when completing the interest holder primary identification information in a transparency report. It's always an individual. So if you find that you're actually getting to a point where you're seeming to come to a conclusion that, well, maybe the interest holder is a corporation, then it's highly probable that you have not analyzed Ltsa, the act itself, completely, as well as analyze the landowner transparency regulation as well. The regulation goes insofar as describing the details around the meaning of indirect control and the chain of relevant intermediaries. So the purpose of Ltsa is always to trace through any relevant intermediaries to identify the ultimate interest holder, which is always an individual or interest holders who have that indirect interest in land. Now, as you've probably seen this in previous presentations, in Ltsa, the interest holder in a relevant trust is the beneficial owner. So that for detailed description of, or meaning, I should say, detailed meaning of the beneficial interest holder in Lotr, the relevant section is section 2. And in a relevant corporation, the interest holder is the corporate interest holder, and that can be seen in section 3 of Lotr. And in a relevant partnership, it's the partnership interest holder as detailed in section 4 of Lotr. The last definition I wanted to cover is settlor. And settlor is effectively the entity that establishes the trust, and it could be a person or a corporation. So now, and this is covered in the definition in Lotr in section 1 of definitions under settlor. So if an interest in land is in the name of a trustee of a relevant trust, it does not include a settlor who is a trustee of a relevant trust or a beneficial owner of the interest in land. So if the trustee is an individual and is the reporting body, what it's saying here is if the trustee happens to also be the beneficial owner or a settlor, then in Lotr you don't have to disclose it. So you don't. The definition basically says that if the trustee is, if the settlor is also the trustee and the beneficial owner, then you don't have to disclose the settlor. In which case, in the transparency report, you would indicate no settlor. So what we've done here is attempted to try and provide a bit of a cheat sheet for you. It's really a summation of when Lotr triggers might be required. So I'm just going to try and cover this fairly expediently. So the first triggering event always is every time there's a registration or call it an application that's made to register an interest in land, all transferees and all reporting bodies must file a transparency declaration. Now, if the transferee is a reporting body, then a transparency declaration and a transparency report are required as well. Then the question is what are your specific references to Lotr? So section 10 speaks to the requirement for filing a transparency declaration, and sections 10 and 12 speak to the requirement for filing of a TD and a TR by a reporting body. So now, the only times that reporting bodies are excluded from having to file a transparency report is if they fall under one of the categories under Schedule 1 and 2 of Lotr. So the exclusions where they're excluded from being either a relevant trust or a relevant corporation. So the next one is all pre-existing owners of an interest in land. So this is the requirement under Section 15 of Lotr. So that is currently in force. So before November 30th, 2021, all pre-existing owners of an interest in land who are reporting bodies only are required to file a transparency report. And those filings can actually occur right now. You as legal professionals can certainly file those. The actual owners of the reporting bodies cannot file them by themselves. They will have to seek the services of a legal professional to file that electronically through My Ltsa. So you can do that right now. The next trigger is a change in an interest holder. So whenever there's a change in an interest holder, Lotr requires reporting bodies to file a new transparency report to update the information. And that requirement is to be filed within 2 months of becoming aware of the change in the interest holder. And that's covered under Section 16. The next is when a registered owner becomes a reporting body. So again, the obligation here is on reporting bodies only. So when they become a reporting body, the obligation is that they have to file a transparency report within 2 months of becoming a reporting body. And your reference section here is section 15, 4 and 5. The next is when a registered owner ceases to be a reporting body. So within 2 months of ceasing to be a reporting body, the registered owner that were formerly a reporting body will then have to file a notice to the administrator as required under section 17.1. The last two, so in the case of a pre-existing owner that ceases to be a reporting body or transfers title, and when that occurs prior to November 30th, 2021, they have to, basically there's no requirement for them to do anything. So a pre-existing owner right now who has owned property prior to November 30th, 2020, when Lotr became into force, if they cease to own the property, or they cease to be a reporting body because they transfer that title, they're not required to do anything whatsoever. The transferee who then assumes ownership of that new property will be obligated to file under the first requirement, which is as the registration of an interest in land. So that's covered in section 15.2 of Lotr. And lastly, the requirement under section 17 is that when a reporting body finds that they've made an error or have not completed a previously filed transparency report, there's a provision there that they can actually file a new and updated transparency report to either correct information or complete information that was previously not completed. And that can be done anytime at the discretion of the reporting body. And that's a provision under section 17. Of note, it's not mandatory, it's discretionary. So we're getting into some scenarios. We've heard from many notaries and certainly from the association for some guidance on specific scenarios that you generally tend to deal with on a regular basis. We've got probably 4, maybe 5 scenarios that I'm going to try and provide some answers to and maybe some guidance, and hopefully this is helpful for you. The first one, which we commonly receive questions on, is, and I'm just going to walk through it step by step. The first one is in the case where a child purchases a property and is registered on title, and a parent is also on title with a 1% interest, for example, so as to fulfill the lender's financing requirements. The first question is the parent a trustee of a relevant trust? So the answer is, really the question you're asking yourself is, is the parent holding the 1% in trust for the child as a beneficiary? So if the parent is, then the answer is yes. Then the parent is a trustee that's holding that 1% interest for the child as a beneficiary. If not, then the parent and child are basically simply joint tenants, and you would just file a transparency declaration and no transparency report is required. Is the child a beneficial interest holder? So similarly, yes, if the parent is holding the 1% interest for the child as the beneficiary, and if not, then again, you don't need to file a transparency report. It's just basically a joint tenant relationship. Is there a settlor? So this goes back to the terminology that I covered earlier. So the answer here is no. If the settlor is also the trustee of the relevant trust or a beneficial owner of the interest in land, then there is no settlor. And in the transparency report, if you are filing a transparency report, then you would actually say no. But in the case where you actually have no transparency report, then you don't even have to think about the settlor. The example in number 2 is where 2 individuals are to be registered on title as joint tenants, and one of them provides the down payment. There is a bare trust agreement that states that if the property sells, the person who provided the down payment will get the down payment back before the 50-50 distribution subsequent to the sale. And so the question here is, must a TR be filed? So no, this is a joint tenant relationship. TR is only required if one individual is holding an interest in trust for a beneficiary. So based on the scenario, our understanding is that there is no trust relationship, that they are in fact a joint tenant relationship. The third sample scenario is where, as an example, a brother and sister purchase a property and are to be registered on title, with the brother having a 49% interest and the sister having a 51% interest. A trust agreement that has been established by the sister states that the sister is the sole beneficiary of the brother's 49% interest. So a couple of questions here. What does the sister file? So the sister, as the transferee, is an individual and must only file a transparency declaration. What does the brother file? So the brother, as the transferee, is also the trustee of a relevant trust because he is holding that 49% in trust for the sister. So the brother is the transferee of a relevant trust and must file a TD and a TR. In the TR, the sister is named, is declared as the beneficial interest holder. And there is no settler in the scenario because the settler is also a beneficial interest holder, who is the sister. The next scenario, when a person dies, what must be filed? So in the first case, when, let's say, the title is transferred to the joint tenant. So this is where you're filing a transmission to a surviving joint tenant. So a TD must be filed and possibly a transparency report if the transferee is a reporting body. So in certain cases, the transferee could be a corporation. But in most cases, the transferee is an individual, the joint tenant, and you're just filing a transparency declaration. Now, in the case where the title is transferred to an executor of an estate, so you will have to file a TD. And then because the trust is excluded under Schedule 2(1)(b) of LOTA, a transparency report is not required. So 2B is an exclusion of a testamentary trust. And then the last one is when the title is being transferred to an administrator of an estate. And so TD must be filed, but the trust is also excluded under Schedule 2(1)(e), which is an administrator of an estate. And so they're excluded from having to file a transparency report. So in this case, it's just a transparency declaration. The one question we've received as well is, does LOTA require an implied trust to file a transparency report? So the short answer is no. The relevant trusts, per the definition of LOTA in Section 1, relevant trusts do not include implied trusts. They only include express trusts, including bare trusts. And so I'll pass it over to Shannon.
Okay, thanks, Ruben. So I'm going to be going over some of the My Ltsa system information today because we do get quite a few questions about using Lotr. So first thing I want to talk about was when filings are required with an application to register an interest in land. So this is Section 10, when a transparency declaration is required, and Section 12, when a transparency report is required. And what's imperative in this case is that you must start with a transparency declaration. You must do this if the transferee is a reporting body or not, but if the transferee is a reporting body, the transparency report automatically becomes nested underneath the transparency declaration in the dashboard. So you can't create a transparency report first and attach it to a transparency declaration later. You have to start with the transparency declaration. So as you can see in this example below, there's a transparency declaration on the top. In this case, there would have been two transferees who were both reporting bodies. So that's why you see two transparency reports nested below the transparency declaration. So those will need to be completed separately from the transparency declaration. All three documents will need to be certified and e-signed. And when the status on the right-hand side there changes from draft to ready for submission, you can attach it to your land title package in EFS. So once these documents have been filled out, certified, signed, paid for, etc., you can go into EFS and input the transparency declaration ID number, as you can see in the red box there on the screen. So something that's really important is to please ensure that the correct transparency declaration ID number is being used. So if an incorrect ID number is being used, the only way to correct it is by withdrawing the entire package and resubmitting it with a new transparency declaration ID number. As you can imagine, that comes with a financial cost, but it also comes with having to create a new transparency declaration, having to get it recertified, having to get it signed, etc. So there is no provision in the Landowner Transparency Act to accept an updated transparency declaration. There is a provision in Lotr to accept an updated transparency report. So for example, in a transparency declaration, if you accidentally put that the transferee is not a reporting body when they are, and you submit it, if the transfer hasn't been registered yet, you would have to withdraw the entire package and resubmit with a new transparency declaration stating that the transferee is a reporting body with the nested underneath transparency report. If a mistake is made and the wrong transparency declaration ID number is made, or there's incorrect information on that transparency declaration, and you don't notice until the package is fully registered, you cannot withdraw this. You have to email lotr@ltsa.ca and attach a new transparency declaration and possibly a report with the correct information and explain what happened. The Lotr administrator, who's Ruben, will then reply acknowledging that the transparency declaration was improperly filed and not compliant with Lotr, and an annotation will be added to the record. So this is something that's really important to double and triple check that the right transparency declaration ID number is being added to your land title package. Now, for filings required from pre-existing and other owners, or on a change of interest holders or determination of incapacity, or of a new transparency report to correct a previous transparency report, you must only file a transparency report. So under section 15, 16, 17, there's no obligation for a transparency declaration in this case. So on the Lotr dashboard, you'd simply press create transparency report. And something to note here is that the filings required from pre-existing and other owners must be filed on or before November 30th, 2021. So once you created the transparency report on its own in Lotr, you simply submit it through Lotr. It doesn't need to be attached to a land title package. It's just submitted simply through your MyLTSA account straight to Lotr. There's also the ability to submit applications and notices through the Lotr dashboard. So these are the application to omit information, the application to correct information, or a notice to the administrator. And these are found under the other registry actions box on the dashboard. So as you can see with the red outline box, you click that and you have the ability to do those applications and notices. And another thing to note is that these three filings are the only filings that can be made by an individual without a legal professional. So if one of your clients wanted to submit an application to omit, an application to correct, or a notice to the administrator, they could do that themselves if they had a MyLTSA Explorer account. So that's some information that you could pass on. Lastly, before we get to questions, we've made some updates to our website recently. So if you haven't visited yet, we highly encourage you to do so. It's landtransparency.ca. So this is the landing page. And as you can see, there's some categories at the top: filing, search, enforcement, about, resources, and system help. And in each of these categories, there's more information and more subcategories. So if I were to go into the filing category, you can see on the left-hand side there that there's more information about certain sections of LOTA, fees, exclusions from Lotr, etc. Most recently, we added this quiz onto the website. So it's something that you can show to your clients or use yourself. And as you answer each question, it will go through and give the appropriate answer based on your responses. So this is a really good tool. Lastly, we also have the system help So as you can see, there's subcategories along the top there: transparency declaration, transparency report, notice to administrator, etc. So when you land on the system help page, the first page is just meant to give you a general overview about filing to Lotr. And as you can see, there's a video there. So that's about a 6-minute long video that shows you how to make a transparency declaration, how to make a transparency report, how to attach your transparency declaration into EFS, and it shows you how to submit your land title package after you've done your Lotr documents. Along the top there, the transparency declaration, transparency report, notice to administrator, those links are also clickable and show further, more in-depth step-by-step instructions if required. And there's also the ability to add your name to our mailing list. So we send out a Lotr newsletter about every 2 weeks, and that it contains information about new policy, new procedures, new direction from the province, any kind of changes to the system, updates to our website, etc. So highly encourage everyone to sign up for the newsletter. And this is at the bottom of every page on our website. So if any page you're on our website, you can just scroll to the bottom and you'll see this where you can enter your email address. And it's a great way to keep up to date about what's happening in Lotr. All right, that brings us to the end of the presentation. So I see there's some questions that have come in. So Ruben, if you're ready, I can start asking you the questions.
Yes, thanks, Shannon.
Okay, so regarding the November 30th deadline, do you have an estimate of how many pre-existing owners that are corporations or joint tenants or tenants in common own properties where one other owner on title holds the interest for a beneficial owner?
That's a question from Ron. Thanks, Ron. It's a great question. I don't have the actual estimates, particularly for one, which is corporations. I know we've done some preliminary estimates probably a year or two ago. The challenge is in estimating or identifying the second part, which is where let's say, as you described there, where an individual or corporations even might be holding title in trust for a beneficial owner. And based on the land title register, it's very difficult to actually even identify those numbers. So, the short answer to this, unfortunately, is I don't have those estimates, Ron. But I'm happy to just chat further with you offline if you're looking for a bit more information, and happy to try and see if we can get some numbers if you so required.
Okay, thank you. So on slide 6, question 2, and this is the scenario where there was one person supplying a down payment and they would get that down payment back before they split the rest 50-50. Why would there be a bare trust agreement when there's simply an agreement about funds?
Yes, so I don't know why there would be, I can't answer why there would be a bare trust agreement. This is an actual question that we have received in the past. I do believe that the bare trust agreement itself in this particular scenario, it's a bit of a red herring. But when you look at the facts itself, all the details really outline that the requirement, there's some agreement to that the down payment that will be returned back to one of the individuals before the 50-50 distribution. And there's nothing here in the facts that indicate that one individual is a trustee holding an interest, a beneficial interest for the other trustee, the other beneficial owner, or anybody else. So because there's no indication that there's anything other than just a simple joint tenant relationship. So yeah, I don't know, Ron, why there would be a bare trust agreement in this case. So perhaps BCNE might be able to provide further guidance on that.
Okay, in your first example, if an only child is on title as parent did not qualify for the mortgage, the father is the 50% beneficial owner but not on title. Can you go through that scenario?
Yeah, so the child is on title. So and the father is 50% beneficial owner. So the child will have to file a transparency declaration, which and then declare that the child would declare that he or she is a trustee of a relevant trust, and then proceed on to complete a transparency report where the beneficial interests holder would be the father declared in the transparency report. And then if there is a settlor, you have to do the analysis in Lotr. If there's a settlor, you'd indicate who the settlor is. Likely not one, and then complete the transparency report.
Okay, so can LTS say, please make it possible to attach a declaration later? If different people in the office are responsible for preparation of these, it's very annoying to have to do the report first. I think this might mean to attach a report later, as she has to do the declaration first.
Right. So generally there's good reason system-wise as to why we had to design Lotr in a manner where one good logic there is whenever you're preparing Lotr to register an interest in land, your starting point should always be the creation of a transparency declaration, and that's how the act flows, and that's how we've designed a Lotr to actually follow the flow of the legislation. So you always want to create the transparency declaration, which establishes then, do you or do you not need to then file a transparency report? So then, if you are a reporting body, if your client's a reporting body, then you flow on to preparing the transparency report. Now, having said that, you can always, once you create your TD and TRs, you don't have to complete them. They can always sit they're always nested in your dashboard, and you have a file reference, and you can always come back anytime to complete or correct your TD and TR as long as you haven't submitted it. So it's always available to you. So unfortunately, there are some good system reasons that we actually can't do that. But if you actually want to discuss this offline with us, certainly just reach out to Shannon or myself, and we can maybe try and provide a further guidance.
Okay. Once a TR report is filed for a relevant corporation, does it have to be filed the next time the corporation buys another property if no changes in the corporation?
So the short answer is yes. So every time that there's an application, so an acquisition of land, and an application is made to register that new interest in land by the same corporation, your requirement under Section 10 states that you're required to file a transparency declaration. And because this is a corporation, Section 10 and 12 apply, which is file a transparency report unless the corporation is excluded under Schedule 1. So my suggestion is this presentation will be made available after today, and I would turn your attention to that table that we provided, what I refer to as a bit of a cheat sheet, to refer to as to when the triggers are for filing TRs.
Okay. Is there a definition of implied trust in the Act or regulations?
Yeah, so there is no definition of implied trust within LODA and its regulations. The implied trusts are simply excluded by way of not being excluded, by way of not being included within the definition of relevant trusts as contained in Section 1 of LODA definitions.
In the TR, can you please explain the bullet points in this section, describe how the individual is an interest holder?
Okay, so those bullets are extremely complex and they're pretty lengthy. I don't think I have enough time to actually go through that in great detail. But what I can say is those bullets are derived specifically from sections 2 and 3 and 4 of LODA. So they're not discretionary. They're extracted right from the LODA itself, the legislation. So if you need a bit more understanding of where those bullets and what they mean, then I would encourage you to actually look specifically to sections 2, which is beneficial owner, section 3, corporate interest holder, and section 4 in the case of a partnership interest holder.
Okay, can you please clarify, are all interests that are held jointly, whether children or parents, not considered relevant trusts?
I don't quite understand this question, Matthew.
I think he's asking if there's joint tenants on title, or is that not considered a relevant trust then?
I think the answer would be it depends. It could be held jointly, but the question you would want to ask is anyone holding an interest in trust for a beneficiary? That is the question you want to ask. Is anyone acting as a trustee of a relevant trust? And if the answer is no, then you can consider them as joint tenants and not have to then file a TR.
Okay. So a joint tenancy wherein a mother transfers her daughter onto the title with her. However, a deed of gift has been executed to confirm that the beneficial ownership does not pass until the mother dies. Does the daughter need to file a transparency report?
I believe, and I probably need to get a bit more facts here. Margaret, I know you and I have had some conversations before on other examples. I believe you do, but I would probably need to ask a bit more questions to get some clarification. It sounds like there is an interest that's being held in trust. But yeah, happy to, Margaret, I think you have my contact number. Please do reach out. I'm happy to actually work through that scenario with you.
I do believe there is a provision in the Act that talks about contingent on the death of an individual. So Margaret, I would maybe look to the Act to search for that section. Thank you. Okay, can you expand more on the notice required under section 24 of Lotr?
I'll do my best here. So section 24 really is a requirement, it's an obligation on the reporting body to provide notice to interest holders and settlers. And the common questions that I get is who provides the notice? Is it the obligation of the legal professional or reporting body? Lotr is very clear that it's the reporting body that's obliged to provide the notice. And the next question is, what is the form of notification? Certainly acceptable forms of notification is email notification to each interest holder and settler of this one. Written notifications, those are always acceptable forms of communication. And then what needs to be provided, those are specifically set out in section 24, 1, 2, and 3. And they're very detailed, so you can actually just follow those guidelines. And that is a requirement that the reporting body must take reasonable steps to give written notice prior to filing the transparency report.
Okay, so we just have 4 last questions. So this we'll ask these 4 questions, and that will be the end of our question and answer period. So I have a client that has bought 6 acres in a company, and they are a reporting body, and a TD needs to be filed, maybe TR. They are in the midst of subdividing this property into 20 smaller properties. Does each newly created lot require a TD, or does the first TD deal with this all?
So there's 2 parts to this question. In the first case, a TD, because it's a company, very likely a TD and TR, as Shannon had mentioned, unless for some reason or other the company is an excluded reporting body. So yes, definitely a TD. Now, the second part is after subdivision, is a TD required? It depends. The issue is, after subdivision, would the company be transferring the subdivided lots to other individuals or entities? That's the outstanding question. And so if there's a transfer, then yes, you would have to file a TD and a TR if it's transferred to a reporting body. And Steele, if you have further follow-ups on this one, I'm happy to discuss further on that, because there's a few different scenarios there that we might need to work through.
Is a TD required if an existing owner is changing their name and submitting Form 17 fee simple with the name change certificate attached?
Generally not. It's just a name change. So you're not really requiring a transparency declaration. There's no transfer.
Okay. Can you give an example of when there would be a settler? Would this be someone like the public guardian and trustee?
I'm not sure about the scenario with the PGT. We'll have to look at that, but
A PGT, they are excluded under section.
Yeah, that's right.
2, yeah.
Right. What I've seen, Steele, is in some complex commercial transactions with multiple layers, and by that I mean multiple intermediaries. There are situations where you have a corporation that actually is granting land for, let's say, a multi-family development. And so the corporation then starts with establishing the trust. And so the corporation becomes a settlor, and then there would be a nominee company, for example, that is holding the interest in land as trustee, with several corporations, limited partnerships, and general partners within the intermediaries. That's generally where I've seen from dealing with some of the legal professionals out there.
All right, thanks. All right, so this is our last question. I'm not sure if you'll be able to answer this, but please tell me what your personal definition of an implied trust is.
Hi, Dan. I don't have a personal definition. However, I can perhaps provide some, maybe direct you to some resources out there. So, my best understanding, I'm not a trust expert here by all means. So my role is just to confirm that implied trusts are not included in LOTA. But effectively, an implied trust is a trust that has not been expressly created by the settlor. And there are two types of implied trusts, resulting trust and a constructive trust. And so constructive trusts are not created explicitly by a settlor. It is a form of equitable remedy imposed by a court order to benefit a party that has been wrongfully deprived of its rights. And so that's kind of, and there's a lot of definitions out there, and I think there's other trust laws that it could probably be a good reference point. So I'm not an expert in trust law at all, by all means. So hopefully that has given you a little bit of answer, and anybody who's a trust expert might have a bit more knowledge around that area.
Okay, so I think that brings us to the end of our time today. So if we didn't get a chance to answer your question, or you have follow-up questions, I encourage you to email lotr@ltsa.ca.
Shannon, sorry to interrupt. If you don't, we can actually spend a few more minutes if you want to address those last few that have just popped in, if that works for you.
Oh,
sure, that's fine.
Okay.
Thank you.
Okay. Is that the case that a subdivision does not require a TD and TR?
I'm trying to, it depends if the subdivision has transferred, or if it's the subdivision occurs and the name of the company, the company is still the interest holder of those subdivided lots. If the company is still the holder of the subdivided lots, then you don't have to file TDs for each of those lots.
Okay, I think that was connected to it. Okay, so we understand that the PPT and Lotr filings with respect to trust should reflect mirrored information. Will the Lotr be comparing the information in the PTT form as a way of auditing information?
Yeah, I really don't know. As the administrator of the Landowner Transparency Act, my role is not to audit any information for any other purpose than Lotr purposes. I have no access whatsoever to PTT information. So it's really administration of the Act as required by LOTA. That will certainly be at the discretion of the Enforcement Officers Division under the Ministry of Finance.
Okay, and then I think Daniel just has a follow-up to his previous question. So if bank requires mom to go on title because of the mortgage, then they had no intention of creating a trust, therefore it is not implied and it is therefore excluded.
If that is your analysis, and that there is no trust in that scenario, that no interest is being held for a beneficiary, then that's absolutely fine. So it's really up to you to make that conclusion, the analysis and the conclusion. So.
Okay, so sorry, as I was saying, if you have questions, we're happy to answer them. If you didn't have a chance to answer them now, or sorry, ask them now, but our email address is lotr@ltsa.ca, and that's a great way to get a prompt response from us. Thank you.
Thanks so much, Shannon. Sorry, I probably threw you off there, but thank you for answering the rest of those questions.
No problem.
We appreciate that.
Thank you.
And thanks, Ruben. Thanks, Shannon, for being here. We appreciate all the information you provided and, of course, your sponsorship. And I will pass it over to Chad to wrap it up for us this afternoon. Thanks, everyone.
Thanks, Trista. And again, Ruben, Shannon, thanks so much. The LTSA has been very approachable and very responsive in terms of getting clarifications out. And we've had that feedback certainly from notaries. So our appreciation to you for your time today, and also to the notaries here. Great turnout. Obviously an issue, that we're still learning and working through. And so having LTSA give us this time today is greatly appreciated. And also thanks again to notaries for being here. Coming up, just so that you can mark your calendars, and we'll certainly remind notaries of this for the upcoming weeks, we do have a virtual student job fair, which we're kind of billing as a career fair because it's being held in a virtual environment. So the new cohort of notaries who will be coming through, it's an opportunity for them to get to meet practicing notaries who may be interested in either hiring a staff notary or looking for a business partner potentially, or even selling their practice. So it's a forum for you to sort of highlight as a notary what it is you might be looking for, and for those students to get a chance briefly to meet you in that virtual setting. Also an opportunity for the association to explain to those new notaries coming through in that cohort a little bit about what we do, and to hear from other notaries in terms of their careers and how varied their practices have been. So it's not so much a job fair as opposed to just something about their career potential and opportunities as professional notaries. And we're looking forward to that. There'll be a reminder to register for that coming out from the association. That's February the 6th, starts at 10 a.m. Also on your calendars, you've likely noted, February 10th is our next Lunch and Learn. Daniel Bover and myself will be presenting the British Columbia Notaries Association strategic plan. Thanks very much for making time over your lunch today to join us. We appreciate your participation. Have a great afternoon, everybody. Bye-bye.